close enough?
Certainly. So if we look at what the relationship we are actually discussing in this case, it is that between the owner of a alcohol serving establishment and a third party, as you said, who is not a user of the highway. In this particular case, our third person in question, the respondent, happens to have been a patron at their facility. That said, there was nothing particular about the facts of this case that made that relevant. The person who was injured was outside of the particular facility on the street, and that person could have been a third party at a neighboring establishment, or perhaps at the Grey Cup football game that was also ending at the same time.
Wasn't the injured party also drinking that night?
Correct,
okay.
They were. The appellants assert, however, that because they were outside of the facility and the contact between the two was not related to their mutual presence at the Oktoberfest event, that person could have been any third party. Further, the concern is that the duty being imposed is not that the owner of a alcohol serving establishment owes a duty to its patrons. We're okay with that. In fact, that already exists per Jordan, Menno and Jordan. Rather, we're asserting, as the trial judge and the appeal judge have called it, it is a duty to all third persons who are not users of the highway, not just to their patrons who may encounter their other patrons.
So if it happened inside, there would be a duty of care. The minute they step outside, there's no sufficient proximity.
If the event had happened inside, it would have been a different scenario because the appellant in that case would have had an additional connection with the defendant, or pardon me, with the respondent in this case, and thus there would have been additional proximity created by the fact that the respondent was on the premises of the appellant. Because in the current scenario, what we are dealing with is a bar owner and a third party, the nature of that relationship is fundamentally defined by the behavior and the activities that that patron undertakes. The counsel for the respondents assert that it is possible to establish a prima facie duty of care by looking inside the analysis that Chief Justice McLaughlin did in evaluating the categories of prima facie duty of care. I will proceed to discuss these categories and why the appellants feel that the particular proposed duty of care does not fit within those categories.
Just before you leave that, the proximity, is it not related to the degree of intoxication? As Justice Saron mentioned, if the patron is completely intoxicated and steps outside, if it's foreseeable inside the bar, why isn't it then foreseeable, or is there not a relationship of proximity when you step onto the sidewalk?
The appellants assert that once the person, the third party, is not inside of the facility, which is what the scenario we are faced with today, that the only connection between that